Welcome to SENDiass4BCP's webinar on refusal to assess appeals. Today we'll be looking at your right of appeal, the legal test for an EHC needs assessment, things to consider and ways of establishing your case, your reasons for appeal, considering mediation and how to appeal to the SEND tribunal should your dispute not be resolved. I will also share with you some useful information such as where and how you can access some additional support. You are likely here because either yourself or your child or young person's early years setting, school or college have requested an EHC needs assessment and the local authority have refused this request. An EHC needs assessment is the first part in a process for obtaining an education, health and care plan. This is a legal document creating legal duties on local authorities and the Integrated Care Board, previously the Clinical Commissioning Group, or Health, for children, young people with special educational needs who require provision above the level of support a mainstream setting can typically provide from within their own resources, referred to as SEN support. If the local authority refused to carry out an EHC needs assessment following a request, they are required to provide their reasons why, as well as how to appeal the decision within 6 weeks of the request. This will be sent to you in a letter detailing the decision. You must keep this letter as you will require it in order to submit an appeal. It is this that provides you with this right. You will then have 2 months from the date on the decision letter to consider mediation and to enable your right of appeal to remain open. Following your choice to mediate, the certificate following this provides you with your right of appeal to the SEND tribunal. You may wish to consider checking your eligibility for legal aid, as this can cover the cost of a solicitor preparing your case. You can check this on the government website or search for legal aid eligibility. If a local authority is requested to carry out an EHC needs assessment, they must do 2 things. Firstly, consider whether the child or young person has or may have special educational needs. And secondly, whether they may need special educational provision to be made through an EHC plan. If the answer to both of these questions is yes, then they must carry out an EHC needs assessment. So, in appealing the decision to carry out an EHC needs assessment, this is what we will need to evidence. When looking at the first part of the test, whether the child or young person has or may have special educational needs, it's useful to first look at the evidence that the local authority used to make its decision. This could include information from the early years provider or school, college or post-16 provision, including attendance and attainment information. Any assessments carried out at the early years school, college or post-16 provision. Evidence of support which has been put in place and what has worked and what has not. Professional reports or advice, including diagnosis assessments if applicable, and also your own views and observations. If the decision seems at odds with the evidence, you may need to look no further than the documentation and reports of the LA's own professionals. If the evidence supports the local authority's decision, you will have to look elsewhere for evidence to back up your case. Reports from professionals such as educational psychologists can be extremely important to your case, but they can also be very expensive. A medical diagnosis, for example, autism or ADHD, will be helpful, but it's not essential. It may be that the school or college can now provide further information to support your case. You may wish to consider further information which may be necessary, such as reports or statements from teachers or the SENCO, referral documents for support or statements from outside agencies or professionals, such as a paediatrician, speech and language therapist, psychologist or occupational therapist. Information from others known to your child or young person or family, such as a social worker or youth worker, school reports and test results, and also views from your child or young person, preferably from a third party. With regards to the second part of the legal test, whether they may need special educational provision to be made through an EHC plan, there are 3 ways you may wish to consider approaching your case. Firstly, a full assessment is the only way to find out what the difficulties are and what help is needed. The school or institution may not be able to supply all of the educational help needed unless it receives extra help from the local authority. Or the school or institution has provided all the help that could be expected, but the child or young person has not made enough progress. Where the first point applies, you need to make the case that advice from a number of different professionals is needed to fully understand your child's difficulties, or yours if you're a young person. In other words, professionals do not yet understand enough about the difficulties, and only a full investigation can help everyone understand the nature and severity of the difficulties and decide what help is needed. For points 2 and 3, you need to make the case that the needs may not be met without an EHC plan. You do not have to prove that an EHC plan is necessary, only that it may be necessary. Example 1. A full assessment is the only way to identify your child's difficulties and find out what your child needs. Jack has been suspended from school twice in the past term. Although he receives a lot of extra help for his behaviour, Jack doesn't seem to understand what he has done wrong. I believe that difficulty with understanding schoolwork may be a factor, but nobody seems sure about why Jack has difficulty learning or why he behaves the way that he does. Example 2. The school or institution may not be able to supply all the educational help needed unless it receives extra help from the local authority. The nursery school has had to provide much more help for Rosie than they would normally provide for children with special needs without EHC plans. The staff at the nursery believe Rosie will need an EHC plan to manage mainstream school. Example 3. The school or institution has provided all the help that could be expected, but the child or young person has not made enough progress. The school has given my child all the help that could be expected, but she has not made enough progress. Layla has received a high level of help for over a year and her progress is very slow. The other children are leaving her further and further behind. Example 4. The school or institution has provided all the help that could be expected, but the child or young person has not made enough progress. The school has been able to give my child all the help that could be expected, and she has made progress, but only with a great deal of extra help. Now she's coming up to the year she's 16. The college she wants to go to cannot do all the things she needs without getting extra help. Before appealing to the SEND tribunal, you are required to consider mediation. Mediation is a more informal way of solving a dispute between yourself and the local authority, also sometimes including the Integrated Care Board, who are the health authority. It's a free service to you whereby a mediator, an independent and impartial party, facilitates a confidential meeting with the aim of reaching an agreement on the points of dispute, potentially preventing the need to apply to the first-tier tribunal. We do have a separate webinar available to you on this topic should you wish to know more about this process. It also includes information on the option of early dispute resolution with BCP Council, which is an informal way of potentially resolving your dispute. If you do not wish to mediate, firstly, make contact with the mediator within 2 months of the decision. Explain you have considered mediation, but wish to appeal straight to the tribunal, requesting a certificate. You will then receive a mediation certificate within 3 working days, providing you with your right of appeal to the first-tier tribunal. You will need this certificate to send with your appeal paperwork, so keep hold of it. If you initially say you do not want mediation and receive your certificate, but then change your mind, you should call the mediation advisor back, still within the 2-month window, and explain that you have changed your mind and you would like to try mediation. If you do wish to mediate, firstly, make contact with the mediator within 2 months of the decision. Explain that you wish to mediate on a refusal to assess decision. Mediation will then be arranged within 30 days by the mediators. Inform them of any supporters also attending the meeting before the mediation itself. Supporters could include a friend or a SENDiass officer. You may also wish to request another professional attends with you to provide evidence, such as a health professional or representative from the school. You'll then need to prepare the issues you wish to discuss, along with any additional evidence you may have. It's advisable to share this information with the mediator and the local authority prior to the mediation date, so all parties are fully informed of the issues to be discussed, ensuring your meeting can be as productive as possible. If mediation does not resolve your dispute, or you chose not to engage in mediation, but have received a certificate to say you have considered it, you are then able to apply to the first-tier tribunal, also referred to as the SEND tribunal. You'll be required to submit the following for your appeal to be registered: the local authority decision letter and the mediation certificate, a SEND 35A form, the EHC needs assessment request and supporting evidence which was submitted, as well as any additional evidence you intend to rely on. All of this will need to be sent to send@justice.gov.uk, either within 1 month of the mediation certificate or within 2 months of the date on the decision letter, whichever is later. Once you have sent your appeal to the tribunal, they aim to reply within 10 working days. These days do not include Saturdays, Sundays, bank holidays, or any day between the 25th of December to the 1st of January, or any day in August. This can take longer when the SEND tribunal receives a high number of appeals around the same time. In its registration letter, the SEND tribunal will tell you about important dates. It will tell you when the local authority are required to respond to your appeal, giving you a deadline to send further evidence and tell you when the hearing date will be. The deadline for the local authority response to your appeal is usually within 30 working days of the appeal being registered with the SEND tribunal. The local authority must say whether it opposes your appeal and why. All of this information must be received by you and the SEND tribunal by the deadline for the local authority's response. You should tell the SEND tribunal if any of the information the local authority was required to send to you is missing, or if you did not receive it on time. You'll be provided with a date whereby you are required to submit any further evidence you wish to rely upon. Refusal to assess appeals are then usually heard on the papers, meaning a decision will be made by a judge based on the information and evidence presented to them. There will be no physical hearing, and you will not have the opportunity to present a verbal argument to the tribunal. The tribunal will then notify both yourself and the local authority of its decision. If you require any further support with your refusal to assess appeal, you can visit our website at SENDiass4BCP.org, where you will find lots of free resources to help you. You can also email us at help@SENDiass4BCP.org, or you can contact our advice line, open Monday to Thursday, 9:30 till 12:30.